Well, we have breaking news tonight in the federal criminal investigation of Donald Trump's possession of government documents, including classified documents at his Florida residence. The Wall Street Journal is reporting tonight that Kash Patel, a close associate of Donald Trump's, has reached an immunity agreement with the Department of Justice and will soon be forced to testify under oath to a federal grand jury investigating the case. Prosecutors obtained the immunity agreement with Patel after he appeared before the grand jury in October and refused to answer questions by invoking the Fifth Amendment on the grounds that his answers could incriminate him. Kash Patel was the last person Donald Trump put in charge of his dealings with the National Archives about the documents that the archives was trying to retrieve from Trump's Florida home. Before the FBI obtained a search warrant to search the residence in August, Kash Patel said publicly Trump declassified whole sets of materials in anticipation of leaving government that he thought the American public should have the right to read themselves. Never mind that he hasn't allowed the American public to read those documents. Patel went on to say, I was there with President Trump when he said, we are declassifying this information. We will see if he is now willing to say that under oath. Kash Patel served in the Trump administration until the day President Biden was inaugurated. In a speech tonight in Washington about next week's election, President Biden began by describing what happened to Speaker Nancy Pelosi's husband when he was attacked with a hammer that produced a skull fracture. That happened to him in his home in a case prosecutors call attempted murder. After referring to that, President Biden said this.
We don't settle our differences in America with a riot, a mob, or a bullet, or a hammer. We settle them peaceably at the ballot box.
Our first guest tonight, Glenn Kirschner, was in the courtroom today in Washington when we learned that some Trump supporters wanted to settle the last election with rifles. In the federal criminal trial of the so-called Oath Keepers for seditious conspiracy, a secretly recorded audio revealed the leader of the group, Elmer Stewart Rhodes, saying this after the January 6th attack on democracy.
We should have brought rifles. Could have fixed it right then and there. Like closer from the lamppost.
We should have brought rifles. We could have fixed it right then and there. I'd hang effing Pelosi from the lamppost. A message that Elmer Rhodes wrote to Donald Trump in the last days of his presidency was also introduced in court today. The message urged Donald Trump to use the military to hold on to power and refuse to leave the White House. The message said, if you don't, then Biden, Kamala will turn all that power on you, your family, and all of us. You and your family will be imprisoned and killed. You and your children will die in prison. Elmer Rhodes wrote the message to Donald Trump after being told by Jason Alpers that he could get that message to Donald Trump. After seeing the message to Trump and becoming disturbed by it, Jason Alpers contacted the FBI and provided them with the written message and the audio recording of Elmer Rhodes saying we should have brought rifles. The Rhodes message to Trump also said, I am here for you, and so are all my men. We will come help you if you need us, military and police, and so will your millions of supporters. That was, of course, a very insulting lie about Donald Trump's millions of supporters, a couple of thousand of whom actually showed up to fight for Donald Trump on January 6th. That's a couple of thousand out of 74 million law-abiding Trump voters who never have joined and never would join a violent political crusade. A court filing has revealed some of the emails that a California judge ordered turned over to the January 6th committee by one of Donald Trump's election lawyers, John Eastman. In an email dated December 31st, 2020, one of the lawyers on the Trump team, Kenneth Cheesebro, wrote this to John Eastman. Merely having this case pending in the Supreme Court, not ruled on, might be enough to delay consideration of Georgia, particularly if Pence has the legal ability and will to insert himself, at least enough to win delay. Possibly Thomas would end up being the key here, circuit justice, right? We want to frame things so that Thomas could be the one to issue some sort of stay or other circuit justice opinion saying Georgia is in legitimate doubt. Realistically, our only chance to get a favorable judicial opinion by January 6th, which might hold up the Georgia count in Congress, is from Thomas. Do you agree, Professor Eastman? And John Eastman replied, I think I agree with this. So there's John Eastman, who served as a Supreme Court clerk for Clarence Thomas and who has remained close to him and who has remained in lifelong close touch with Clarence Thomas's wife, Virginia Thomas. There he is saying that, knowing Clarence Thomas as he does, he agrees that Clarence Thomas was their only hope of getting a delay from the Supreme Court involving the Georgia presidential election result. The friends of Clarence Thomas know that Clarence Thomas would not recuse himself from that case, even though the law requires him to recuse himself from a case in which his spouse has an active interest. The members of the conspiracy who were friends with Clarence Thomas, the conspiracy to overthrow the presidential election, had their eye on the most publicly compromised member of the Supreme Court in the court's history as their last best hope, because they could not use rifles. Leading off our discussion tonight is Glenn Kirschner, a former federal prosecutor and an MSNBC legal analyst who has been following the Oath Keepers trial from inside the courtroom. Also with us, Bradley Moss, national security attorney. And Glenn, I want to begin with immunity. This situation now where Kash Patel has immunity, has to go back in to the grand jury. He does not have Fifth Amendment protection anymore. Of course, he doesn't have immunity from perjury. If he commits perjury in his testimony, then he can be charged with crimes. But what else does it mean to this investigation that someone who was personally involved with the documents once they arrived in Florida now has immunity to testify?
You know, it suggests to me, Lawrence, the Department of Justice is focusing on Donald Trump. That's why they're willing to immunize Kash Patel. You know, it's interesting because immunity is not ordinarily the prosecutor's friend, because when you immunize somebody, you're essentially giving them a pass for their own crimes. And then you're going to ask a jury in the future to credit them, believe them when they testify about the crimes of others. Let me tell you, that makes for some robust defense cross-examination of an immunized witness. But the Department of Justice, first of all, litigated the issue of whether Kash Patel's invocation of his Fifth Amendment right was legitimate or not. We can tease something out of that. What we can tease out is it was probably a relatively minor crime that they were dealing with, one where there was an open question as to whether Kash Patel should be allowed to invoke his Fifth. But once a judge ruled he has a viable Fifth, then the Department of Justice had to make the decision. Do we have enough to charge him and try to develop him as a cooperating witness with a guilty plea and cooperation agreement? Or should we immunize him so we can work our way closer to Donald Trump? It looks like they went the immunity route. That may be good for Kash Patel, but boy, is it bad for Donald Trump.
Bradley Moss, your reaction to this immunity deal?
Yeah, if I'm Donald Trump, this is the last thing I want to see, because now Kash Patel has no way to avoid testifying. He invoked his Fifth Amendment right to avoid testifying the first time. Now he's been immunized. He's going to have to talk to the grand jury. He's going to have to describe what he saw, what he knew about Donald Trump's awareness of the documents' existence, what he actually saw and witnessed in terms of any declassification efforts. and what he knew about efforts to relocate or conceal the boxes and the records within the boxes once that investigation had started and once the issue had been subpoenaed. This is one more material fact witness that the government has lined up as part of this grand jury presentation to bring what I expect at some point in the next few months to be an indictment against Donald Trump for Espionage Act and for obstruction charges.
Glenn, I imagine in your experience as a federal prosecutor with immunity deals that there are witnesses like Kash Patel who get immunity and then go into the grand jury and still somehow try to cling to some kind of way of protecting their principle, some kind of way of trying to protect Donald Trump in this case. What do prosecutors do when they sense that is going on?
We breathe a sigh of relief because we're reluctant to grant immunity in the first place, because, as I say, that's giving somebody who committed crimes potentially a pass for their criminal conduct. But if they go into the grand jury and they lie, for openers, Lawrence, that's perjury. They may be an accessory after the fact trying to help their criminal associate. It may be obstruction of justice. It may be evidence of a conspiracy. The reason I say we may breathe a sigh of relief is because now we have so much evidence that we can use to charge them and then flip them and develop them as a cooperating, testifying witness.
And Bradley Moss, as this case goes forward, they've got immunity now with Kash Patel. This testimony, when they get it, brings them as close to Donald Trump in terms of testimony as they have come so far.
Correct. We know that they've also spoken with Christina Bobb, the lawyer who, as far as we understand, signed that attestation back in June, saying there were no more records when, of course, there were. We know they've spoken with at least one, if not two, different staffers who were assisting Donald Trump, who were part of the effort to move the boxes and move the records after the subpoena was issued. They're building the entirety of the case. If you're going to bring this kind of case against Donald Trump, you want it to be ironclad. You want to dot every I and cross every T. They're getting all the way to the inner core and making a decision, which I don't think they've made yet, but I'm assuming they're getting ready to, which is, are we going to indict the former president?
Glenn Kirschner, what was it like in the courtroom today when the jury heard on audio tape there Elmer Stewart Rhodes say we should have brought rifles on January 6th?
You could have heard a pin drop. You saw the jurors riveted to this undercover recording that was made by a civilian who was a former military member himself. And the circumstances were left a little murky, not fully explained by either the prosecutors or the defense. But, you know, Lawrence, we have been listening to lots of cell site experts and Facebook records custodians and FBI agents reading incriminating signal chats between and among Oath Keepers, and it kind of tends to lull you into comfort. And all of a sudden, you hear the marquee defendant, Elmer Stewart Rhodes, head of the Oath Keepers, in his own voice, saying, what happened on January 6th was good, but my only regret was we should have brought rifles. We could have fixed it then and there. I would have hung effing Pelosi from the lamp post. And all of the jurors, I think, you know, reacted to that. I would say it's all over, but the verdict, of course, no verdict is a sure thing. And the defense has promised that Elmer Rhodes will testify. So I think we're all looking forward to that.
Glenn Kirschner and Bradley Moss, thank you very much for starting off our discussion tonight. Really appreciate it.
Have a good night.
Thank you.